Welcome to our ongoing lecture series on the right to research and international copyright law. And today we're moving into a discussion of the human rights aspect of the right to research. And we've been using that phrase, the right to research, in various ways. And today I want to have a discussion and interact with our various lectures to really unpack what we mean when we talk about the right to research as an aspect of human rights, as opposed to a type of, for instance, exception to copyright. And there can be a difference between those two things, and they're related to each other, and teasing out both the differences and how they're related to each other is the topic of today's lecture. Analytically, one interesting starting point is this is the first page from Wesley Hoffeld's 1919 article in the Yale Law Review, Fundamental Legal Conceptions as Applied to Judicial Reasoning. And that article gives us a language to distinguish between different kinds of legal operable concepts that we sometimes call rights, but really have differentiations within them. And I think the two main ones that I just want to call your attention to today is the difference between how Hoffeld terms a right versus a privilege. And so as his terminology, a right creates a duty on someone else. Someone has to do something in order to respond to your right. Whereas a privilege creates no right on the other side. So a privilege you can think of as a freedom to use something. So in the intellectual property space, many of the limitations and exceptions are privileges. So if you have a fair use, we might call it a right? But if you're applicable to if you're qualified for a fair use exception, what you really have is there is no right of the rights owner to stop you. But the rights owner, does the right owner have an affirmative duty to help you in some way? Sometimes maybe, but most often no. Most copyright privileges don't create a duty on the rights holder or the state to do anything. Human rights, on the other side, are very much defined by the duties they create. The whole purpose of human rights is to create duties on the state, usually not private entities, but we may get into that a little bit as well, and there's cutting-edge jurisprudence on that. But human rights create duties on the state to act or to refrain from acting in certain ways. And so I want to just for you to keep those relationships in mind as we talk about the human rights aspect of this equation today, and then as we move into the discussion, maybe we'll refer back to some of this language. But I think it's one of the types of language that can help us distinguish between how copyright user rights operate as defined as exceptions versus human rights that create duties upon the state. So with that, we have with us today 4 experts in the field. The first 3 scholars that we have are all either from or living in South Africa currently. South Africa also has a very interesting and established connection with human rights jurisprudence. It's the home of one of the most progressive and forward-thinking constitutions in the world. It's the home of one of the most progressive, forward-thinking constitutional courts in the world. And it's a place where human rights has really, I think, become integrated into almost all forms of academic scholarship that takes place in the country today. So let me just make a quick reference to one of the leading kind of South African constitutional thinkers of the transition period in constitutional discourse, so Samtani. This is published in the South African Journal of Human Rights, and the title of his paper is "A Bridge to Where," right? If you think of where the South Africa was coming from, it was coming from apartheid. And he makes the case, well, for sure we know that we're a bridge from apartheid, a bridge from a culture where authority is justified through force, through coercion, right? And what is it moving to? And the idea that Murenick says is we're moving to a culture of justification, where power has to be justified instead of legitimated through coercion. So legitimated through reason and legitimated through justification. And then what's the role of rights within that? And the structure of the South African Constitution is very clear. And I think in the human rights discourse generally, but maybe it's South African Constitution even more than human rights. And this is kind of my question to tee up, is that it's very clear in South African human rights discourse. And here's the what we refer to as the limitations clause, that if an action impacts something protected in the Bill of Rights, then the government, it doesn't mean the government can't do it. So we can say, oh, well, the right of research, everybody has to be allowed to both receive and impart information, right? And then, can the government take any action that restricts rights to receive and impart information, or to do science, or to enjoy science, the rest of it? And at least in the South African Constitution, that issue would shift down into the limitations clause, right? You have heightened justification requirements for action that a state takes that negatively impacts human rights. And then there's kind of a different question that becomes more complex about, well, what if they don't take the positive impact to build the kind of institutions and structures that Klaus and Sanya were talking about? So where does justification lie within this human rights story? You know, when we say there's a duty to do something, does that just mean every state has to do it? And if they're not, they're violating human rights? Or, you know, how does the justification aspect of rights seeking and rights claiming and rights justifying come in? Justification becomes what the state is required to do anytime it doesn't adequately meet a human rights duty, right? And we'll talk more through this lecture about, you know, differences between positive rights and negative rights. And so to define that a little bit further, a positive right or a positive duty in association with a right is a duty for the government to take affirmative action to promote or fulfill the full scope of that right, right? So if we say, in order to have a right to research or a right to science, or however we're calling it, the state must build institutions. It must build a legal enabling environment. It must make certain investments to make sure that everybody can enjoy both the production and access to research, right? So those are claims on positive actions of the state to take certain affirmative actions, to allocate budget, etc. So those positive actions generally are seen as triggering a progressive realization duty, that those duties must be kind of rolled out over time, and they're subject to available resources. And some scholars say, well, those duties aren't enforceable at all because the duties are so mushy, it's hard to tell what the state is supposed to do and how do they justify, you know, when they fall short. And then on the other hand, we have what we call negative duties, sometimes referred to as negative rights, which is the duty of the state to not take affirmative action that decreases people's access or enjoyment to the right. So for instance, if we think the full scope of the right to research requires that researchers to have you know, full access to as many research materials as that they can get access to, and then the state creates a new policy to say, from here on out, in order to access the state archive, you have to pay, you know, an extortionate fee. So we're decreasing access to that knowledge to everyone. That would implicate the duty to respect the right, or the negative aspect of the right, where the state has actually taken affirmative duty that decreases people's access to the right. Or for instance, you know, censorship may be the easiest example. You know, we're going to say that no researcher can publish any research that doesn't comply with the censor's ideological commitments or whatever. we're going to ban all conservative or all liberal or all left-wing research, or we're going to ban research into certain topics. For sure, that would be a state action that would implicate that right to research or the free expression right or the right to science. And then that would normally require that entity to give a justification, to describe its compelling justification and why this policy is needed to actualize that. And then, of course, the key question that we're going to discuss, in the discussion is, well, what's copyright? Does copyright implicate the positive duty or the negative duty? Is having good copyright policy something that just needs to be progressively realized over time? Or is copyright itself a positive state action that implicates that negative aspect of the right, which is immediately enforceable and must be justified with a very high standard of justification? Is there utility? I think one of the things we've been skirting around, I think Klaus mentioned it a little bit, is that there is a right to the moral and material interests of authors and inventors, which is wrapped up in that same part of the right to science. And that one is often mobilized by the publishing industries, by WIPO, etc., to really frame intellectual property itself as the human right. And then if that's true, at most you have kind of a conflict between rights, as opposed to really a discourse that gets you through and attacks the problems you see with copyright. So is human rights itself just internally conflicted and therefore doesn't get you anywhere? Or is there some way to order this discourse that actually gets you to cut through some of the claims of authors? Or is it better, as Sara mentioned, to use concepts, for instance, of development, of public interest, of just good instead of right? And should we be organizing our justifications based on those kind of more broadly accepted economic, social outcomes, and just analyze the doctrines for their outcomes and use that higher order of the public interest to really justify various policy positions, etc. I leave those hanging. It's for us to discuss, the whole semester, but also some here.